Hi friends, welcome back. Today we will discuss about the latest updates and notification with regard to the reverse charge under GST, and we will get into the details of the reverse charge provision under GST, and also need to understand what are the things which a business or a professional needs to do to do a proper compliance of GST. So let's start. What is GST? So what is reverse charge? Reverse charge is defined under section 2 subsection 98, and which says that liability to pay tax by the recipient of supply of goods or services or both shall be, instead of the supplier, shall be on will be an obligation for the recipient. So for example, if Mr. A is supplying a good or a service to Mr. B, instead of Mr. A levying GST and collecting it, Mr. B, being the recipient, needs to pay the GST as a reverse charge. Now, what is the background of reverse charge? So reverse charge is where the recipient is liable to pay tax, and is common to many countries like Canada, where it is applicable on import of services and intangible properties. Normally the supplier pays the tax. In certain cases the receiver becomes liable to pay tax, and that's why it's the chargeability is getting reversed, and that is it is called reverse charge. In India, reverse charge under service tax, it was very common. There were a lot of specified services wherein the recipient of the service was required to pay reverse charge. Uh, and but and this is basically because the government are unable to collect taxes from that particular unorganized sector. For example, in case of GTA, Goods Transport Agency, under the service tax, there was a provision of reverse charge because government was unable to collect service tax from the transporters. So therefore, and because of this, the government had to introduce. So reverse charge is an instrument in the hands of the government to levy and collect tax from sectors or from a class of taxpayers from whom they cannot directly are able to collect, maybe because they don't have the proper infrastructure or information to collect. So this is basically the background of the reverse charge. Now what are the what are the provisions? So earlier reverse charge under GST was levied mainly on insurance agents, services of a director to a company, manpower supply, GTA, non-resident, and there were services by an individual advocate. So in those scenarios, earlier reverse charge was very prevalent under the service tax regime. So this is not something which is new. In some of the states, there is a concept called purchase tax, wherein the receiver of the goods was required to pay VAT on the under the purchase tax regime. Now let's understand what is there under reverse charge under the GST regime. So basically there are two main provisions which covers the provision of reverse charge under GST. One is section 9 subsection 3, which says that the government may, on the recommendation of council, by notification specify categories of supply of goods or services or both, the tax on which shall be paid on reverse charge basis by the recipient of such goods or services. Basically what it means that the government can specify supply of goods or services or both, in which the recipient of goods or supply will be required to pay GST under reverse charge mechanism, and all the provisions of this act will apply to such recipient of service or goods as if he was the person who was liable to pay tax from the first place, and all the provisions will apply to him. As of now, reverse charge under section 9.3. So 9.3 is basically a section wherein it doesn't matter whether either of the parties are registered, unregistered under GST. It can be when both the parties are unregistered. Suppose a healthcare, a hospital unregistered under GST, not required to be registered. If they take service from an advocate, they need to pay reverse charge. They need to register themselves and pay reverse charge. So this is basically in case wherein both parties can be wherein the recipient of the service or goods can be registered or may not be registered prior to this transaction. So reverse charge is basically, these are the specified supply of services in wherein the reverse charge is applicable under GST. And if you are recipient of any of these services, it can be a non-resident service provider or a GTA, goods transport agency, in case of legal services by advocate, firm of advocates, arbitral tribunal, sponsorship services, specified services provided by government or local authority, services by a director to a company, insurance agent, recovery agent, transportation of services on import, permitting use of copyright, radio taxis like Uber, Ola. In these specified supply of services, there is a 100% reverse charge basis. So this is provision 9.3. Please understand, under 9.3 there are specified supply of services on which reverse charge is applicable, and this is irrespective of whether the recipient is registered or unregistered under GST. Maybe because of section 9.3, because of any of these services, the recipient have to get itself registered and then pay GST on a reverse charge basis. This is with regard to section 9 subsection 3. Now what is 9 subsection 4? Now this is very very dangerous and a provision which is causing lot of worry, and there are a lot of news about this provision. So this talks about supply of taxable goods or services both by a supplier who is not registered to a registered person shall be paid by such person on reverse charge. Suppose I am registered, now I buy stationery from an unregistered local shop, then I have to do a self invoicing on myself and pay GST on reverse charge basis. So this is section 9 subsection 4 talks about a scenario where a registered person receives supply of goods or services from an unregistered person. In that scenario, the liability shifts from the unregistered person to the registered person. And however, there is an exemption which is given a few days back. The government has given an exemption as per section 11 subsection 1, which gives the government power to exempt goods or services or both partly. So using that exemption, the government has notified notification number 8 2017 that exemption shall be applicable where the aggregate value of such supplies of goods or services or both received by a registered person or from any or all suppliers is up to 5,000 rupees a day. So for example, I purchase stationery from a local vendor for 4,500 rupees, then I do not have to pay reverse charge on that. But if I pay 5,200 rupees, then I have to pay reverse charge, GST on reverse charge on the full amount of 5,200. Please understand, this is not per dealer. This is aggregate of all the dealers. This is aggregate of a one day. So all the expenses which you debit to your P&L account, to you as you treat expenses, all the expenses which you treat on a particular day, if you purchase or you've received services from unregistered dealer amounting to more than 5,000, you have to do reverse charge on the full amount. This is causing lot of problem. This is apprehension. There are a lot of rumors flowing around this provision. So section 9.4 is basically when both the party, when the recipient is registered and the supplier is unregistered. So some of the points which I want to focus now. So this exemption is only up to 5,000 per day, and this exemption is only in case of intrastate. In case of interstate, even though those situations will not arise in many scenarios, because in case of interstate anyways the supplier needs to be registered. So there will not be a scenario wherein, and in case of an interstate, there will be an unregistered supplier. But even though, so this provision is, this exemption is only for intrastate, that is within the state, you purchase from within the state. This limit of 5,000 is per day, and if the amount exceeds say about 5,100, then GST needs to be paid on the full amount 5,100. Limit is in respect of all the supplier. That means that this 5,000 limit is for all the supplier. This is aggregate of all the supplies for one particular day, and all the persons who are required to pay under reverse charge have to register for themselves. Moving forward, there is something which I want to focus on, because of this subsection 9.3, which talks about specified services, and 9.4, which talks about all the generic goods and services wherein the recipient is registered and the supplier is unregistered. Now take an example. Now assume a situation wherein a business is required to pay GST under reverse charge under 9.3, even if it's not engaged in taxable supply. For instance, we take example of a healthcare unit, wherein it would automatically need to comply with subsection 9.4, which supply to unregistered dealers. So I take an example. Suppose Apollo Hospital takes services of an advocate. Now they need to pay GST under RCM as per provisions of 9.3, because as per provisions of 9.3, advocate is a specified services on which GST needs to be paid on RCM. Even though Apollo Hospital, since healthcare is exempt, even though Apollo Hospital is not supplying any taxable supply of goods or services, is not engaged, they have to register and pay RCM under 9.3. Now the problem starts because under 9.4 it says that if you are registered and if you are taking supplies of goods or services from unregistered, then you have to pay GST on RCM on all the inward supplies for more than 5,000 per day. So does that mean that now Apollo, since they have taken services from an advocate, they have to register? Now they are registered, now they have to do RCM on all the expenses more than 5,000 per day, taking into the provision of subsection 9.4, because that automatically triggers, because now Apollo is registered and that provision is applicable to all the parties who are registered and who are taking inward supply of goods or services from an unregistered party. Also, taking discussion forward, if you are not required to pay GST under 9.3 or section 9.4, but you are still required to show total turnover, that is, for example, Apollo Hospital needs to now file the GSTR 1, 2 and 3, and they have to show the complete exempted supply also, which otherwise would have been totally exempted, even though they are not paying any GST, but they have to show, because the forms are like that the full disclosure is required to be done. They need to file all the returns mandatorily, and this to my mind is little harsh, and I think this is not the objective of the law. So basically, so my worry is that even though you are exempt under GST, if you have to pay RCM under 9.3 on those specified services, then provisions of 9.4, which talks about taking services or goods from an unregistered dealers, automatically triggers, and you have to start paying reverse charge on all the inward supplies of an amounting more than 5,000. So this is what I wanted to stress upon. Obviously we will get input of reverse charge when we pay. We can get input of reverse charge, so that's not an issue. And so this is a latest amendment, latest notification, and this is something which is very latest. So I thought that I will also bring this to you, and this will help you to understand the impact of reverse charge and how the reverse charge will also impact exempt sectors and sectors like education sector, healthcare sector, which are, even though not under GST, even though they are not engaged in supply of any taxable goods or services, still they have to register, they have to file returns and comply with the GST provisions. So this is what I wanted to bring to your notice today. Thanks for watching this video. If you have any queries, you can WhatsApp me too. You can WhatsApp, you can email also. Bye till the time we come again with a new video. Thank you.